Hello, and welcome to Navigating the Estate Plan with Caress Law. I am Tammi Caress, founder of Caress Law, and today I decided to take one of the workshops that I put on regarding the common myths of estate planning and try to condense it and put it into this mini podcast. If you want to know what a will is and how to avoid probate, today will be a good introduction to that. I will also talk about some common myths and common questions that I receive almost on a daily basis. And now it's time for the disclaimer. The information contained in this podcast and associated material is intended to furnish listeners and users with general information on matters that they may find to be of interest. The information in this podcast provided by Caress Law and its agents are for general guidance and is not intended to replace or serve as a substitute for any advisory, tax, estate planning, or other professional or legal advice, consultation, or service. Sometimes we may reference third-party materials or websites. Such links or references are only for the convenience of the listener, user, or browser. Caress Law and its agents do not recommend or endorse the content of third-party information or sites. You should consult with appropriate Caress Law professionals or other professional advisors for advice concerning specific tax, estate planning, or other matters before making any decision. In summary, this podcast is not legal advice. If you need legal advice or before acting or making any decision with anything talked about in the podcast, seek the counsel of an attorney. Thanks so much. So the first fact or fiction that I'm going to talk about today is that planning is only needed for when you die. It is not needed prior to. And I think most people probably know that's not true. So we're really talking about if during your lifetime you are no longer able to pay your bills for yourself, or make financial decisions, or maybe you are, but it's just too mentally exhausting because you've reached a stage in your life where you're just tired. And I get that quite a lot from my much older clients. So in order to plan for that time or that moment in your life, we want to have certain documents in place. And that would be the durable power of attorney for finances, the healthcare power of attorney for healthcare, and then your medical directive. And so the durable power of attorney is really naming a person who is going to pay your bills, talk to the cable company for you, handle any sort of legal matters that you might need. And it's an agent that you authorize to act in that capacity on your behalf. A healthcare power of attorney is similar to the financial, but we're dealing with healthcare. This is the person who will make healthcare decisions for you when you cannot make them for yourself. And then finally, your medical directive. This is a document that allows you to set forth your medical wishes. And this document might be a form that the state requires an attorney like myself to use, a statutory form, or it might be a form that gives you a little bit more opportunity or leeway to write your own wishes. So the form can be different in many different jurisdictions, depending on which state you live in. The medical directive is a really important form to let your healthcare representative, which is the person appointed under your healthcare power of attorney to make decisions for you, to let your healthcare representative understand and know your wishes with regard to your medical care and treatment. One piece of advice that I can give regarding who you name in these documents, you definitely want to name someone who you trust. You want to name someone who's responsible, and you want to name someone who will carry out your wishes. I also recommend that you talk to these people who you are considering naming to let them know, make sure that they're okay and are willing to serve in that role, and then also have a discussion with them about what your wishes are and what your values are, and things like that. It's really good to be open and frank with them while you have the ability to do so, as opposed to upon incapacity, having these people try to guess. So really encourage open discussion. Another common myth of estate planning is that if you die without a will, the state will make one for you. So it's worded kind of funny, but essentially, if you pass away and you don't have any estate planning documents in place, it is true that the state will determine who inherits from you. So the state doesn't make a will for you, but it's like they kind of do, in the sense that they're directing who will inherit from you at your death. So you definitely want to make a plan. And even if you are a single person and you think it doesn't matter, I don't really have anything, it does matter. And let me just give you an example. I had an estate that I helped settle and administer. This person was single. He lived in a home that he inherited from his own parents, I think from his mom. And he did not have any children. And he pretty much was, he was a hoarder. I'll just say he was a hoarder. So this is what happened. His house actually was a beautiful house in its day. Wasn't quite as beautiful when he passed, but it was a beautiful house in its day and had lots of opportunity for that person to come in and make it shine again. So that house was really his only asset. Well, he didn't have a will. And so guess what we had to do? We had to find who his heirs are. So heirs are those people who inherit from you when you die without a will or without another estate planning vehicle in place. It is those people that the state determines who will inherit from you. And the state will actually go extremely far out to find any living heir to inherit. Many people think that the state will actually inherit if you don't put a plan in place. It's actually not true. The state inherits, or I guess they kind of hold the money, if you will, in the estate for a period of time before it actually goes back to the state. Anyhow, so we look to state law to see who inherits from you. And oftentimes it would be a parent. If there's a living parent, it might be siblings. It might be nieces and nephews. It could be cousins once removed. It really goes, most times the statutes go pretty far out to find any living heir. So in this scenario, what happened is we had to do that. And oh boy, as soon as we filed this probate, which is, by the way, it's a matter of public record. When you file a probate, we had to do that because he had a probate asset and he had no other means of giving that asset to his heirs. So once that was filed, we got so many potential heirs contacting us. And what happens is there's actually these companies that scour the probate records, and they'll kind of do their own little research, and they try to find these heirs. And how they get paid is they have the heirs actually assign some of their inheritance to them. It's actually, I think, very horrible business. But nonetheless, that's what happens. So we had a lot of people come out of the woodwork. Well, not only that, we had to hire a company to actually go and search and find all the heirs. And what made it even more complicated in this estate is this person had a father who had been married several times and had several children. And it was a very long and very deep rabbit hole. And what does that translate to? Well, that translates to a lot of money being wasted just trying to make sure we find all the heirs. who are entitled to inherit under state law. So the only asset was this house, which luckily, because of the location and where it was at, there was enough money to be able to sell that property to someone who wanted to restore it. And there is money in the estate. There ended up being, I think, close to 30, not quite, close to 30 beneficiaries. And we had to go through the court to make sure the court allowed us to stop looking for beneficiaries. It turned out to be a very long process, and it turned out to be a very expensive process. Now, had this person just made a will and said, I want all my estate to go to, maybe he had a charity in mind, maybe he had a close friend, the people who inherited from him are people who never met him. So very important to have a will. That's just a lesson learned. But it could have saved a lot of energy and time. I mean, the people who really got paid in that probate administration are the attorneys, which full disclosure, I was an attorney, but also the person in the family who stepped up to be the personal representative. So it could have been a very simple probate had he had a will in place. So yes, the state basically determines what happens to your assets when you die if you don't make a plan for yourself. A myth that I often have to educate people on is that a will avoids probate. It does not. A will is the vehicle to go through probate. So if you don't know what probate is, I really encourage you to listen to some of my prior podcasts that talk specifically about probate. And also, I have a podcast that talks about the differences between a will and a trust that will give you a good synopsis of the probate process. But a will does not avoid probate. In fact, a will is what actually gets submitted to the court to settle an estate and is part of opening the probate process. So a will does not avoid probate. If you want to know how to avoid probate, I will put information about that in the show notes below, and that's discussed in prior episodes. What about a revocable trust? Does a revocable trust avoid probate? Well, maybe. Our hope is that it does. And I say hope because it really depends on if you have funded the trust once it's created. Funding the trust means that you are titling your assets that, if you didn't title your assets to your trust, would be a probate asset. So we essentially have a list of these are your current probate assets. Once the revocable trust is in place, there's certain actions that are needed in order to rename your assets, your probate assets, so that the trust becomes the owner. And as long as you do that, probate can be avoided. But if you have one asset out there that you did not title to your revocable trust and it's in your individual name without a beneficiary named on that asset, like, for example, an IRA, or you could have a bank account that just has your name on it and you have no transfer on death beneficiary. If you have a single probate asset out there, that means we are going through some type. So yes, revocable trust avoids probate so long as you have funded your assets to it. So it is not just by virtue of creating the document that does not avoid probate. You actually have a little bit more homework to do once that document is created. Naming a child on an account. Should you do this? Well, most of the time the answer is no. The answer I'm going to give is no. If you name a child, and it's not just a child, actually, any loved one, it could be a niece or a nephew. If you name them on the account, they become an owner of that account with you. And when you pass, that account will be owned solely by whoever is named on it. So if it's a child, if it's a niece or a nephew, they will become the sole owner of that account. What does that mean? Well, if your intention is to have all your assets be distributed to more than one person, let's say you have 2 kids and you want it to be distributed to 2 kids, but you've named your daughter on your account in order to, for convenience. I mean, it's for convenience. Your daughter becomes the owner of that account at your death. Meaning that although your will says, I want my assets divided equally between my 2 children, that account is not governed by your will because it had a joint owner on it. And your daughter, in that scenario, receives those funds. She could decide to share it with her sibling, but she could also decide not to share it with the sibling and take it and do whatever she wants. So effectively, when you name a child or a loved one on the account, you are disinheriting others. The better way to handle that scenario is to add them as a power of attorney. And that's a whole nother episode to talk about that. But essentially, it's making sure that either if you have a revocable trust, that account is owned by the revocable trust, or if you don't and you only have a will, hopefully you at least have a will, your agent under your power of attorney, you can name them on the account as a power of attorney so that when the time is needed, they can write checks and so forth, but it does not disinherit anyone else at your death. Now, the next myth, I'm going to call it a myth, that I get a lot is, well, I should name my eldest child to settle my estate. Many people say, well, we'll just name our kids in order, and it's the eldest child who should have this. If we name the eldest child, that's going to cause the least problem because the eldest is the one that's supposed to do stuff like this. Well, that is not true. The person you want to settle your estate, or the person that you want to be your agent under your power of attorney for finances, is someone who you can trust, obviously, but it's somebody who is responsible, someone who pays their own bills on time, someone who is a good communicator, someone who is going to be fair. This isn't always the first child. And I understand why a lot of people say, well, it's just easier. We'll name children in order of age. But that's just not always the best route to go. You really want to go with who is the one that is best for this role, not just because of their age. Another big one that I get is that a revocable trust shelters taxation. That is a big no. It does not. Now, you can make a plan within your revocable trust and other estate planning documents to minimize the estate tax, which is a death tax. You can map out a plan to try to minimize that tax that might be assessed at death as much as possible. But during your lifetime, creating the revocable trust is not a tax sheltering trust. It is not going to shelter taxes, and it's not going to affect your taxes in one way or another. The fact that it is a revocable trust means that the creator of that trust, we call it the trustor, the creator of that trust can modify or change its terms at any time. And for that reason, along with others, but for that reason, it is not a tax sheltering trust. So by putting your assets in a revocable trust, you are not going to shelter it from creditors, including the IRS. Okay. The last myth I'm going to talk about is only the wealthy need an estate plan. Well, my example that I provided earlier regarding that gentleman who passed away without any kids or a spouse is a prime example. He was not a wealthy gentleman, but his estate ended up costing a lot of money and time. So he could have solved that very easily if he just even had a simple will in place. So that's one reason why, not a wealthy individual could have saved a lot of money had he put a plan in place. And not only that, he would have, at least the assets would have gone to whom he wanted them to go to. Instead, it went to people that he never knew. The other item to discuss is estate taxes. So you hear this a lot, especially when we're in the middle of elections. The federal estate tax, at least right now, is not a huge burden on most estates. However, there is a state level estate tax. So what that means is when a person passes away and they reside in a state that has an estate tax, we have to look at the value of all of their assets. It doesn't matter if it's a probate asset, a trust asset, a retirement account. We look at all of them and we add the values up, valued typically as of the date of a person's passing. And if that value is over the threshold amount for that state, it is possible that there will be an estate tax assessed. Now, for the state of Oregon, we're looking at anyone who has assets and the value is over $1 million. Now, $1 million, yes, it's a lot of money, but when you own a house and maybe you've been contributing to a retirement account your whole life, that $1 million mark is very easy to get to. So only the wealthy need an estate plan? No. If you estate plan can help minimize the estate tax, an estate plan may help put some strategies in place during your lifetime to minimize that estate tax as well. So that $1 million threshold in Oregon is so easy to get to. So we want to plan for that. Washington, by the way, it's a little bit more favorable than Oregon. If you're a resident of Washington, when you pass, the threshold is $2.193 million. So in today's dollars, that's actually not a huge amount of assets when you own a house. Even if you own a life insurance policy, and let's say it's a term policy for 20 years, and it's a $500,000 policy, that can actually get you over that threshold pretty quickly. The other thing to consider is blended families. When you have children from a prior relationship or prior marriage, and now you're entering into a new marriage, having an estate plan in place will map out what is to happen when you pass. It's not going to leave it to the state to decide. And there are ways to, for example, support your new spouse at death, but then guarantee when your new spouse passes that the assets maybe go back to your children from a prior relationship. Those types of things can be worked out. So that blended family happens to everyone, even those who are not the ultra wealthy. Another consideration as to why an estate plan is necessary for everyone is if you have a beneficiary who might have special needs. For example, you might have a beneficiary who is on government benefits. And if they inherit through your trust or through your will, they'll be pushed off those government benefits. There are mechanisms that you can put in place to allow that beneficiary to inherit from you, but also not be pushed off those state benefits. So many reasons to have an estate plan. It's not just for the wealthy. Okay. Well, there's a lot more fact or fictions I could probably go through, but those are the ones that come up the most often and that I wanted to address today. If you want to learn more about kind of these facts or fictions, I routinely put on workshops, as I stated earlier, that you can sign up for. If you go to my website, www.caresslaw.estate, and that's www.caresslaw.estate. I do have a tab in there for my upcoming workshops. And I also have a tab in there for an on-demand workshops if you want to listen to any of those. And they're all free. And I just do them because I enjoy educating the public. I also have a lot of blogs on many of these types of topics on my website as well. Thank you very much for listening today. And until we meet again.